Ma'am, please step out of the car now.
Oh, what?
You are under arrest. This is a stolen car.
Oh, no. This is my car.
The afternoon sun was beginning to dip below the tree line as federal judge Mariah Johnson pulled her 2024 Mercedes-Benz into the driveway of her home. It had been a grueling week, 6 days of presiding over civil rights cases, each one demanding not just her legal intellect but her emotional reserves. This morning alone, she had listened to testimony from a woman who had been denied housing based on her race. This afternoon, a young man whose police encounter had nearly cost him his life had finally received the settlement he deserved. The weight of these stories, the accumulation of systemic injustice she witnessed week after week from the bench, sat heavy on her shoulders. Mariah was exhausted in a way that only someone who carries the responsibility for dispensing justice can truly understand. It was a bone-deep tiredness that sleep rarely touched. It was the kind of exhaustion that came not from physical labor, but from the emotional toll of seeing suffering, of understanding its causes, of knowing that for every person who received justice, there were dozens more who would not. All she wanted now was to step inside, pour herself a glass of the Pinot Grigio she had been saving, and spend the evening with her husband, Michael, and their 2 children. She wanted to help her daughter, Sophie, with her calculus homework. Sophie was struggling with integrals, and Mariah had always been good at explaining mathematical concepts. She wanted to listen to her son, David, talk about his soccer tournament. She wanted to be a mother and a wife, not a judge. For one evening, she wanted that distinction to matter, wanted to be someone other than the person who spent her days rendering judgments about other people's suffering. Her home sat on Ashford Drive, a quiet suburban street lined with mature oak trees that had been growing for over a century. The neighborhood was the kind of place where people mowed their lawns on Saturday mornings and waved to their neighbors. It was the kind of place where nothing bad was supposed to happen, where the biggest community concern was whether the homeowners association would approve the color of someone's new deck. The houses here were modest but tasteful, not ostentatiously wealthy, but unmistakably the homes of professionals. Doctors, lawyers, engineers, people who had worked for their position and had earned the right to live in relative peace and security. There was a sense of accomplishment embedded in the very brick and mortar of these properties. Every home here represented someone's victory over circumstance, someone's triumph over odds. It had taken Mariah 23 years to earn enough to live here. Every mortgage payment represented not just a financial transaction, but a victory over the odds that had been stacked against her since childhood. Her mother had been a nurse, a dedicated woman who had worked 12-hour shifts in hospital emergency rooms to keep the family housed and fed. Father had died of a stroke when Mariah was 7 years old, leaving her mother alone to raise 2 children on a nurse's salary. Mariah's childhood neighborhood had been a place of struggle, a place where ambition was something you had to fight for, where education was the only ladder out. And yet, through scholarships that required her to maintain a 3.9 GPA, through night classes while working as a legal secretary during the day, through an absolute refusal to accept the limitations that society tried to place on her, Mariah had become something her neighborhood had never produced before, a federal district court judge. Her name was on a courtroom door. People stood when she entered the room. Her decisions mattered. She had made it. She put the car in park and exhaled deeply, the kind of exhale that comes after holding your breath for hours without realizing it. The driveway was quiet. The street was quiet. Everything felt as it should. The late afternoon light filtered through the oak trees, casting long shadows across the manicured lawn. This was her refuge. This was the place she had fought for. But as she reached for her briefcase, a leather bag that contained the files of cases she was still reviewing, something changed. The sound of an engine, not the gentle hum of a neighbor's car or the distant rumble of traffic on the main road. This was loud, deliberate, insistent, then the unmistakable crackle of a police radio, the kind of sound that had become omnipresent in American life, the soundtrack of authority and potential danger. A white Crown Victoria police cruiser pulled up behind her, stopping at an angle that positioned it crosswise in the street, effectively blocking her car in. The maneuver was textbook. It was the kind of positioning used when police anticipated resistance or danger. For a moment, Mariah felt no alarm. Police patrolled the neighborhood occasionally. It was part of suburban life, part of the unspoken social contract of a residential area. But even as these thoughts registered, Mariah's instincts, the instincts that had been honed over 15 years in the legal profession, were telling her something was different about this moment. Something was wrong. The officer wasn't turning away. The engine wasn't cutting off. The cruiser was sitting there, lights off, idling. And the officer who had emerged from the driver's side was not moving with the casual stride of someone conducting a routine patrol. He was moving with intention. Officer Ethan Brooks stepped out of his patrol car with the deliberate movements of a man who had already made a decision. He was 38 years old, had been with the police force for 11 years, and had built a reputation among his colleagues as someone who got results. Whether those results were achieved through proper procedure or through the kind of aggressive tactics that made supervisors uncomfortable was a question that had been quietly asked and quietly avoided by the department for a decade. As Officer Brooks approached the Mercedes, Mariah's instincts shifted into the analytical mode that had served her so well on the bench. She remained in her car, hands visible on the steering wheel, watching him in the side mirror. Her legal mind was already running through scenarios. Had she drifted slightly over the center line? Had a taillight burned out? Had she been speeding without noticing? These were the normal, rational explanations for why a police officer would stop your car, but the way Officer Brooks was moving contradicted any of these innocent possibilities. His gait was aggressive. His breathing was audible even from a distance. His eyes were fixed on her vehicle with an intensity that suggested he was not approaching to discuss a burned-out bulb or a traffic violation. His right hand rested near his holster, not touching it, but positioned in a way that made it immediately accessible. His jaw was clenched. This was not a man coming to deliver a friendly warning. This was a man approaching with suspicion already crystallized into certainty. She had studied enough criminal cases to recognize the pattern. This was what was known in legal circles as a pretextual stop, a stop made ostensibly for one reason, but actually motivated by another. The Supreme Court had ruled in cases like Warren v. United States that police could stop vehicles based on any traffic violation, even minor ones, if the officer could articulate even a thin justification. Over the years, Mariah had seen this doctrine stretched in ways that allowed police enormous discretion in deciding who to stop and who to allow to continue unmolested down the street. Officer Brooks reached her driver's side window without any preamble. There was no greeting, no introduction, no statement of his name or his badge number. Just a tap on the glass with the back of his baton, hard enough to startle her, soft enough to technically remain within acceptable conduct. When Mariah rolled down the window, Officer Brooks did not announce himself. He did not state why he had pulled her over. He did not provide any context or explanation for his presence. He simply leaned down, his face filling the window, and gave the first command: "Step out of the vehicle." His tone was not a request. It was a demand, the kind of command that carried the weight of a man who believed his authority was absolute and unquestionable. Mariah, who had spent 15 years in the legal system, who had read hundreds of cases detailing the dynamics of police encounters, who understood with intellectual clarity what was about to happen, recognized the pattern immediately. This was a felony stop. Mariah asked politely, but with a thread of steel in her voice that came from her position of authority, why she was being stopped, Officer Brooks did not answer. He did not provide a reason. He did not explain what she had done or why her compliance was necessary. He simply repeated the command, his voice taking on an edge of impatience, as though the reasonable woman sitting in the car was being deliberately difficult by asking perfectly reasonable questions. "Step out," he said again. And so she did. The moment Mariah's feet touched the asphalt, everything accelerated beyond the point of normal police procedure. Officer Brooks was already advancing toward her with his hands up, gesturing for her to move away from the vehicle. He barked another command. "Place your hands on the hood." The tone of his voice had shifted now, had taken on a quality that suggested aggression was imminent, that cooperation might no longer be sufficient to prevent escalation. She complied immediately. She walked to the front of her car and placed her hands on the hood, her palms flat, her fingers spread, a position of complete vulnerability and submission designed to communicate that she posed no threat. She had read enough cases, had listened to enough witness testimony to know that this was the safest position. Her legal mind was cataloging everything with the precision of someone who understood that what was happening might matter later. The timestamp on her watch, 6:52 p.m., his badge number visible in her peripheral vision, 4922. The presence of a dashcam mounted on the nearby streetlight. She noted this and knew, with an understanding that would prove prophetic, that this moment was being recorded. The camera would, she somehow knew in that moment, become the central evidence in what was coming. The camera would be the witness that Officer Brooks didn't anticipate. It was at this precise moment that Officer Brooks made his accusation. The Mercedes, he said, matched a description, a stolen vehicle, a black sedan reported missing from 3 blocks away just hours earlier. He had received a BOLO, a be on the lookout alert, and this vehicle fit the parameters. She was the prime suspect in a grand theft auto case, and she was now in custody pending the completion of his investigation. What Officer Brooks didn't say, and what would later become the central contradiction in his narrative, was that he had not actually verified any of this information before making the arrest. He had not run the license plate. He had not checked the vehicle identification number. He had not done any of the basic investigative work that would confirm whether this car actually matched the description. He had simply seen a black car being driven by a black woman and had allowed his assumptions to harden into certainty. The original stolen vehicle report, which would emerge during discovery months later, was for a 1998 Honda Accord with a broken left taillight. The Mercedes was a 2024 model year. The vehicles were not similar in any meaningful way. That single characteristic, the color black, was apparently sufficient for Officer Brooks to construct an entire narrative of criminality. Mariah tried to explain. She kept her voice. Level, non-threatening, the voice of someone who understands the psychology of authority figures and the danger of appearing confrontational or challenging. She told him who she was. She offered to provide her identification. She told him her registration was in the glove box, that he was welcome to verify everything immediately. She explained that she had just returned from work, that her children were inside the house, that there was clearly a misunderstanding. She was, by every objective standard, cooperative. She was, by every standard of law enforcement training, the kind of suspect that should de-escalate a situation. Yet Officer Brooks was not descending. He was escalating. Officer Brooks was no longer listening to her words. What Mariah was saying didn't fit the script he'd written. In his mind, genuine innocence would sound different. It would involve the kind of fear and compliance that came from someone who understood they were at the mercy of police authority. Instead, Mariah was speaking with the calm authority of someone who knew her rights, who understood the law, who was not intimidated by the badge. And to Officer Brooks, that calm was itself evidence of deception. It was, in his mind, the kind of composure that came from someone with practice at evading law enforcement, from someone accustomed to talking her way out of situations. It was, in his deeply flawed reasoning, evidence of guilt rather than innocence. He told her she was resisting arrest. She had not resisted anything. She had not pulled away, had not raised her voice, had not done anything that could reasonably be construed as resistance. He told her she was being non-compliant. She had complied with every command. But the words had power. The words had weight. The words created a reality that could be written into official documentation. His hands moved to his belt. His fingers found the handcuffs, the metallic restraint devices that symbolized the complete removal of freedom and autonomy. When he reached for her wrists, Mariah did not pull away, but she felt something shift inside her, some internal transformation that turned the victim of an injustice into someone who was prepared to fight back. The metal of the handcuffs was cold. The cuffs were too tight, the kind of tight that sends a message wordlessly. You are not in control here. I am. Your rights are what I decide they are. Your freedom is suspended at my discretion. Officer Brooks twisted her arm as he secured the cuffs, a movement that was not quite excessive force, but was aggressive enough to send pain shooting through her shoulder and down her arm. As he guided her toward the patrol car, as he placed his hand on her upper back and directed her toward the open rear door, Mariah made a promise to herself. She would make sure that the cost of this mistake was paid in full. Not out of revenge, though there was certainly anger, not out of a desire to destroy this man, though his career would be, is destroyed, but out of a commitment to the principle that no one, not even those of us who have reached positions of relative power, should have to suffer the arbitrary exercise of authority without consequence. If you're watching this right now and you're thinking about what just happened, pause for a moment. What would you do if you were arrested in your own driveway for a crime you didn't commit? Would you stay silent or would you fight back? Drop your answer in the comments below. I read every single comment, and I mean that. Not just some, every one. And if you haven't subscribed yet, now is the moment. Because what happens next, the investigation, the trial, the verdict, will absolutely blow your mind. The system had no idea what was coming. The ride to the police station took 12 minutes. Mariah sat in the back of the patrol car, hands restrained behind her back, and did something that she had never done before in her professional life. She counted. She counted the seconds in groups of 60. She counted the turns the car made. She counted the breaths she took, maintaining a steady rhythm of 4-count inhale, 6-count exhale, a breathing technique she had learned in a meditation class years ago. This discipline, this maintenance of internal rhythm and control, became her anchor as everything external spiraled into chaos. Officer Brooks drove in silence. He did not look at her in the rearview mirror. He did not speak to her. He did not acknowledge her presence, except as one might acknowledge a piece of cargo being transported. She wondered if he was already regretting his decision, if somewhere in his consciousness there was a small voice suggesting that he had made a profound error, or if in his mind he had already constructed enough narrative to protect himself from consequences. She would learn months later during the discovery process that he had not yet run her license plate. The sequence would matter enormously in the trial that was to come. Most officers check first, run the information, verify the vehicle, and then, only if something is actually amiss, make an arrest. Brooks had reversed this sequence. He had arrested first and would check later, a reversal of procedure that was nearly impossible to explain away. The police station was a modern concrete building situated on the north side of the city, a facility that had been constructed in the early 2000s with the modern accoutrements of law enforcement, separate intake areas, interview rooms with recording capabilities, cells designed to be secure. As the patrol car pulled into the underground garage, Mariah felt something she had never expected to feel, the genuine vulnerability of someone at the mercy of a system designed to remove autonomy. The booking process is designed by its very nature to be humiliating. It is, by every intention, a ritual of degradation, designed to strip away dignity and establish absolute institutional control. Mariah understood this as it was happening to her. She was fingerprinted first. The technician, a woman who might have been sympathetic but gave no sign of it, took her right hand and pressed each finger in turn onto an ink pad, then transferred the inked finger to a white card. The ink was cool and slightly sticky. It stained her fingertips with a substance that would take days to completely wash away, a physical reminder of the process. As she pressed her fingers onto the card, she thought about the permanence of fingerprints, about how this moment was being encoded into a system. Then she was photographed. The photographer positioned her in front of a white background. She was told to look directly at the camera to ensure her face was fully visible. Her expression was carefully neutral, not angry, not defiant, not pleading. The photo would become the official record of her arrest, evidence that she was a criminal. Or so the system suggested. Her shoes were removed. They were placed in a plastic bin and slid across a counter. Her belt was taken next. Safety procedure, she understood. The institution did not want detainees to have access to anything that could be used for self-harm. Her briefcase, which contained her judicial robes and the case files she had been reviewing, was logged as evidence and placed into secure storage. She was asked questions. Lots of questions. What was her address? What was her date of birth? What was her mother's maiden name? Each question was a ritual assertion that she had no agency in this moment, that she was being processed, that her identity was being encoded into a system that had decided what she was. She was told she would be moved to a holding cell while her paperwork was processed. The holding cell was overcrowded beyond its design capacity. There were 12 women in a space designed for 6, the institutional assumption being that some would be released quickly, that the space would never need to accommodate the full capacity for long. The smell was industrial, a combination of cleaning solution failing to mask something fouler, a smell that seemed to accumulate in the very walls of the space. It was the smell of human desperation compressed into inadequate dimensions. Mariah stood in the corner and did not speak. She had learned in her position as a judge that silence was a form of power. Silence allowed you to observe, to understand, to maintain your position above the immediate chaos of a situation. Around her, other women were crying. Some were angry, some were resigned, some were clearly experienced with the criminal justice system, moving through the process with the dull familiarity of people who had been here before. Others were first-time offenders shocked by the reality of incarceration, struggling to comprehend how they had arrived at this moment. One woman, a young woman who could not have been older than 22, asked Mariah what she was in for. The question was casual, the kind of question that other people in the cell had asked of one another. Mariah did not answer immediately. She looked at the young woman. She had purple highlights in her hair and tattoos on her arms, and a quality of desperation that suggested this was not her first experience with law enforcement. And she made a decision. "A mistake," Mariah said finally. The young woman laughed, a bitter and hollow sound that echoed in the close space of the cell. "Yeah," she said, "we're all mistakes in here." It was a statement that would haunt Mariah for years to come. The realization that the justice system did not distinguish between people who belonged there and people who didn't, that the machinery of incarceration ground forward without regard to innocence or justice, that it simply processed bodies through a system designed to remove them from society. 3 hours passed in the holding cell. During these 3 hours, Mariah was not offered a phone call. This was a violation of procedure. Detainees have a right to contact an attorney within a reasonable time, but it was also a commonplace violation, something that happened regularly in police stations across the country, something that was rarely challenged because most people in holding cells did not have the knowledge or resources to know they had been violated. She was not offered water. She was not offered information about what would happen next. She was not offered an explanation for why she was being held. No update on the progress of her case, no indication of how much longer the process would take. She existed in a kind of temporal suspension, cut off from the outside world at the mercy of systems she did not control. But even as she stood in that crowded cell, even as the physical and emotional weight of the situation pressed down on her, Mariah was already planning the response. She was already constructing the narrative of what had happened, the evidence that would be needed, the legal theory that would sustain the case she was going to file. It was at 9:47 p.m. that something shifted. A shift captain, a woman named Sarah Martinez, who had 15 years on the force and a reputation for taking her job seriously, was reviewing the day's arrest when she noticed a name on one of the booking reports. Judge Mariah Johnson, Federal District Court. She had heard the name before. She had actually appeared as an expert witness in one of Mariah's cases 5 years ago, a civil rights action involving police conduct. The case had been decided in favor of the plaintiff. Martinez had been impressed by Judge Johnson's command of the law, her fairness, her clear understanding of the issues at stake. What happened next was audible even in the holding cell. There was raised voice, not angry, but urgent, the tone of someone who has realized something important. There was movement. There was the sound of a supervisor looking through files, running a name through a computer, cross-referencing information. And then there was silence, the silence of comprehension, the silence of someone understanding that something significant had occurred. When Mariah was led out of the holding cell, she was not told she was under arrest. She was not given any official notification of her status. She was simply told she was free to go. The charges were being dropped. Officer Brooks had made an error. She would be receiving a formal apology. Mariah was handed a plastic bag containing her belt and her shoes. She was not handed an explanation. She was handed her freedom like it was a gesture of goodwill, rather than an admission that she should never have lost it. Her husband, Michael, was waiting in the station lobby. He was a physician, trained in the science of evidence and reason, and the look on his face when he saw her, the relief, the fury, the protectiveness, told her that the small indignities of the evening had registered on both of them. He held her without speaking. The moment stretched until it became almost unbearable. What you just saw was 3 hours of someone's life being stolen. 3 hours where Mariah Johnson, a federal judge, was treated like a criminal. But here's the thing, this happens to thousands of people every single day, and most of them don't have the resources to fight back. Most of them don't have a federal judge's knowledge of the law. Most of them spend weeks, months, even years navigating the system alone. I want to ask you something in the comments. What do you think should happen next? Should Mariah settle and move on, or should she fight and expose the entire system? What would you do? Tell me in the comments. I read every single comment. On the drive home, Mariah sat in the passenger seat and told Michael everything. She told him about Officer Brooks's aggression. She told him about the stolen car that was not her car, about a 1998 Honda Accord that bore no resemblance to her 2024 Mercedes except for the color black. She told him about the holding cell and the 12 women and the girl with purple highlights who understood, with the wisdom of experience, that the system did not care about the difference between mistakes and crimes. When she finished, Michael asked her the question that would determine the trajectory of the next 18 months. "Are we going to let this go?" he asked. Mariah looked out the window at the streetlights passing, at the orderly suburban landscape that had suddenly become a place where anything could happen, where the rules she thought protected her did not apply. She thought about the young woman in the holding cell. She thought about the statistical reality that Officer Brooks would continue to patrol the same neighborhoods, would continue to stop drivers who matched his predetermined categories, would continue to escalate situations until he got the compliance he wanted. She thought about the cases she had presided over, the patterns she had seen in the system, the way that power without accountability corrupted even good intentions. No, she said, we're not. The next morning, Mariah called David Chen. David Chen was not a man who built his practice on high-profile cases or media attention. He had been practicing civil rights law for 28 years, and in that time, he had learned that individual injustices were only valuable if they revealed something larger about the system that had produced them. He had represented clients in housing discrimination cases, employment discrimination cases, police misconduct cases. He had won some, lost some, but he had never accepted the premise that the system was beyond reform. When Mariah walked into his office the next morning, she came with documentation. She had photos of her driveway. She had notes on the timeline. She had the names of neighbors who had witnessed the arrest. She came prepared as someone accustomed to presenting evidence to a judge. David Chen listened without interrupting. When Mariah finished, he asked her one question. Are you prepared for the fact that this is going to get bigger than you? That you won't be able to control the narrative? That your case is going to become a public symbol of something larger? Mariah said she was. The discovery process began immediately. Chen filed a EFOIA, Freedom of Information Act, request for Officer Brooks' personnel file, his training records, his disciplinary history, and his traffic stop data. In most jurisdictions, this would take months. The process was designed to be slow, to be exhausting, to tire out the people seeking information. But Mariah's name, federal judge Mariah Johnson, and the implicit threat of her involvement accelerated everything. Within 3 weeks, Chen had boxes of documents stacked in his office. What he found as he worked through the files with 2 associates was a portrait of a police officer who had been permitted to operate with almost no accountability for nearly a decade. The complaints began early. In 2015, a woman named Teresa Williams filed a complaint alleging that Officer Brooks had stopped her without cause in a residential neighborhood where she lived and conducted a prolonged search of her vehicle without permission. She had asked him what he was looking for. He had responded that her vehicle fit the description of a car involved in a theft. When she asked for clarification, he had told her to be quiet. The complaint was marked unfounded by a supervisor named Captain Harold Reynolds, who never interviewed Teresa Williams, never examined the facts, simply closed the case with a notation that Officer Brooks acted within protocol. In 2016, a man named James Patterson filed a complaint alleging that Brooks had used excessive force during a traffic stop, that he had been thrown against a vehicle, that his arm had been twisted, that he had been threatened with arrest if he didn't comply with any illegal search. Patterson had called the police station the next day and asked to file a complaint. He was told it was his word against Officer Brooks' word. The complaint was formally logged, but closed without investigation after a notation that insufficient evidence to substantiate claims. Between 2015 and 2023, there were 14 formal complaints filed against Officer Brooks. 14? Each one was dismissed. Each one was archived. Each one was treated as if it had never happened. The cumulative effect was that Officer Brooks operated in an environment where there were no consequences for misconduct, where each violation was treated as an isolated incident rather than a pattern, where the system enabled rather than inhibited aggressive policing. But the most damning evidence was not in the complaint files. It was in the data. David Chen hired a statistician, a woman named Dr. Patricia Hoffman, who had built a career analyzing racial disparities in law enforcement and who had testified as an expert witness in dozens of cases involving police discrimination. Chen gave her one assignment: analyze every traffic stop made by Officer Brooks over the past 3 years. Compare it to the neighborhood demographics. Compare it to the hit rates, the percentage of stops that resulted in contraband being found and citations being issued and arrests being made. Find the pattern if there was one. 3 weeks later, Dr. Hoffman delivered her analysis in a document that was 53 pages long. The findings were stark. They were undeniable. They were the kind of findings that would, once presented to a jury, make it impossible to claim that Officer Brooks' conduct was a series of innocent mistakes. Officer Brooks operated in a district that was approximately 80% white, yet 75% of his traffic stops were of black drivers. This alone was statistically improbable, to the point of being virtually impossible to explain through chance. The mathematical probability of this pattern occurring randomly was less than 1 in 1 million. This was not happenstance. This was pattern. This was intention. But the data went deeper. For white drivers, Officer Brooks' hit rate, the percentage of stops that resulted in contraband being discovered, citations being issued, or arrests being made was approximately 4%. For black drivers, it was less than 1%. Brooks was stopping black drivers at nearly 4 times the rate he stopped white drivers, and he was finding contraband at 1/4 the rate. The mathematical inevitability of this pattern was that Officer Brooks was not using traffic enforcement to combat crime. He was using traffic enforcement to exercise control over a specific demographic, to assert dominance over people he perceived as threats simply by virtue of their race. Dr. Hoffman found other patterns as well. In 2019, Officer Brooks had conducted a vehicle search of a black driver that took 37 minutes. The driver had been asked to remove all items from the vehicle. Papers had been examined. The interior had been searched. It had been a humiliating, invasive process. The same officer stopping a white driver 6 months earlier for an identical violation, a burned-out taillight, had completed the entire stop, ticket included, in 4 minutes. The disparity was not incidental. It was systematic. In 2020, Brooks had requested K-9 units to the scene of a traffic stop 6 times. Of those 6 times, 4 involved black drivers and 2 involved white drivers. K-9 units cost approximately $800 per deployment. The department was spending limited resources at a dramatically higher rate on stops involving black drivers, and the K-9 units had found contraband in exactly 1 of those 4 deployments involving black drivers. In 2018, Officer Brooks had instructed a black driver to sit on the curb during a traffic stop. When the driver asked why, Brooks had responded that it was for safety. A white driver stopped later for the same violation was allowed to remain in her car with the window rolled down. In 2019, Brooks had asked a black driver if he had any weapons. The driver said no. Brooks then asked if he could search the vehicle. The driver refused. Brooks then told him that refusing to consent to a search gave him probable cause to search anyway. He conducted the search. He found nothing. The stop report made no mention of the fact that the driver had explicitly refused consent. When Mariah read Dr. Hoffman's analysis, she wept, not from the violation she had personally suffered, though that was real, not from the humiliation of being arrested, though that was real. She wept from the understanding that Officer Brooks had been conducting what could only be described as a sustained campaign of racial targeting, sanctioned by a department that had received complaints about exactly this behavior and had chosen not to act. She called David Chen. "What do you need from me?" she asked. "Everything," he said. "I need you to understand that this isn't about a traffic stop anymore. This is about dismantling a system that has allowed this to happen. Are you ready for that?" Mariah thought about the young woman in the holding cell. She thought about Teresa Williams, whose complaint had been dismissed without investigation. She thought about James Patterson, whose allegation of excessive force had been ignored. She thought about Officer Brooks operating for a decade without meaningful consequences, knowing that the system would protect him. "I'm ready," she said. This is real data. This is actual statistical analysis. Officer Brooks didn't make isolated mistakes. He engaged in systematic racial profiling, 4 times more likely to stop black drivers, 1/4 the success rate, and the department knew. The department received 14 complaints about this man and did nothing. 14. So I want to ask you, do you think this is just about Officer Brooks, or is this about a system that enables him? Comment your answer. Tell me what you think. And if this makes you angry, good, that's the point. This should make you angry because this is happening in your community right now. This is happening to your neighbors, your friends, your family members. The civil rights lawsuit was filed in federal district court on October the 14th, 2023, naming Officer Ethan Brooks as the defendant and the city's police department as a co-defendant. The charges were specific: false imprisonment, under state law, civil rights violations under 42 U.S.C. Section 1983, and unlawful arrest. Mariah was seeking $200,000 in compensatory damages and requesting punitive damages in an amount to be determined by the jury. The department's response was swift and, in its way, predictable. Their attorneys filed a motion claiming qualified immunity, a doctrine that protects police officers from civil liability if they were acting in good faith, and if their conduct did not violate a clearly established constitutional right. The argument was that Officer Brooks had made an honest mistake in mistaking her vehicle for a stolen one. The arrest, while ultimately erroneous, was not conducted with malicious intent. He had followed the procedures he was trained to follow. Therefore, qualified immunity should apply, and the case should be dismissed before it ever reached a jury. David Chen's response was methodical and devastating. In a 60-page brief, he laid out the discovery materials, showing that Officer Brooks' pattern of traffic stops could not be explained by chance, that his disparate treatment of black drivers could not be dismissed as coincidence, that the arrest of a federal judge based on a vehicle that did not match the description was not a reasonable mistake, but a manifestation of the racial profiling that had defined his career. Chen also argued that the right to be free from racial discrimination by police was clearly established by numerous Supreme Court and Circuit Court precedents. Brooks could not claim that he didn't know his conduct was unconstitutional. He had been trained. He had received policy manuals. He had access to the same case law that all police officers had access to. To claim ignorance of constitutional protections was, Chen argued, not credible. The motion for qualified immunity was denied. The case would proceed to trial. In the months leading up to trial, the city attempted settlement discussions. The negotiation process revealed much about how the system typically worked. The city's initial offer was $50,000. This was a number designed to make the problem go away, to allow Mariah to walk away with some money, and allow the city to avoid the publicity of a trial. Mariah rejected it. The city increased the offer to $100,000. Mariah rejected this as well. The city increased the offer again, $150,000, $200,000. By summer 2024, with trials scheduled to begin in 6 months, the city was offering $250,000, an amount that represented a significant admission of liability, an amount that would have been life-changing for most people, but Mariah didn't see it that way. Mariah's response was communicated through David Chen, and it was absolute. I don't want to settle. I want a verdict. I want a jury to see what Officer Brooks did, and I want them to say it out loud. I want the system to be forced to acknowledge what it has allowed. A settlement allows everyone to pretend this was an isolated incident. A verdict makes it real. The decision to proceed to trial was not made lightly. A trial meant publicity. A trial meant her name in the newspapers. A trial meant her children knowing the full extent of what had happened to their mother. A trial meant the possibility of a loss, of a jury deciding that Officer Brooks had reasonable grounds to stop her, even though the evidence suggested otherwise. But it also meant the possibility of change. It meant the possibility of a precedent. It meant the possibility of a system being forced to confront itself. Most people would have taken the money, $250,000. That's enough to change your life. That's enough to make this go away. But Mariah didn't. She wanted more than money. She wanted accountability. She wanted the system to look at what it had allowed and admit it was wrong. So I'm asking you, what do you think about her decision? Was she right to reject the settlement, or should she have taken the money and walked away? Comment your answer. And if you're thinking she's brave, she's right, she should fight, subscribe and share this video, because what happens next in the courtroom is going to vindicate her decision. The trial began on March 19th, 2024 in federal district court. The courtroom was full. The case had attracted media attention, and there was an understanding that whatever verdict emerged would become part of the historical record of how the American justice system handles police misconduct. Officer Brooks took the stand on day 3 of the trial. He had been coached by the city's attorneys. He had been prepped on how to answer questions, on how to appear credible, on how to maintain the narrative that he had made an honest mistake. He was wearing a suit that did not fit him quite right, purchased specifically for the trial. An attempt to appear professional and trustworthy, his tie was a shade of blue that was meant to project honesty and authority. His shoes were polished, his hair was freshly cut. When he raised his right hand and swore to tell the truth, there was nothing in his demeanor that suggested he was about to contradict everything he had said in his police report. There was nothing that suggested he understood the magnitude of what was about to happen. David Chen began with questions designed to establish the baseline. What was Officer Brooks's training on traffic stops? Brooks answered that he had completed certified training in traffic enforcement and in the legal standards that govern police stops. What did he understand to be reasonable suspicion? Brooks answered that reasonable suspicion meant an officer had observed facts that, in light of his experience and training, suggested that criminal activity might be occurring. What procedures was he required to follow before making an arrest? Brooks answered that he was required to have probable cause to believe a crime had been committed. Each answer was delivered with the precision of someone who had memorized the official answers, who understood that his training was the shield that would protect him. If he could show that he followed procedure, that he did what he was trained to do, then his conduct could be justified. Then David Chen shifted. The entire trajectory of the cross-examination changed. The lawyer stood up, approached the witness, and asked a question that would unravel everything Brooks had constructed. Officer Brooks, you stated in your police report that the vehicle matched the description of a stolen car. Is that correct? Brooks said yes. And the stolen vehicle report was for what make and model? A Honda Accord, black, 1998. And Judge Johnson was driving a Mercedes, black, 2024. Did you consider those to be very different vehicles? Brooks hesitated. In his hesitation, in that moment of pause, the entire case shifted. He understood in that moment that he was being set up, that the question was a trap, that the answer he gave would matter enormously. They were both black sedans, he offered, attempting to salvage his narrative. David Chen let the silence hang in the courtroom. For a long moment, the silence itself was a form of argument. Then he asked to see the stolen vehicle report. The judge granted the request. The report was projected on the large screen for the entire courtroom to see. It specifically noted that the stolen Honda had a broken left taillight. This was a distinguishing characteristic. This was a detail that would allow someone to differentiate between this specific Honda and other black sedans that might be on the road. The judge asked Brooks if he had observed Judge Johnson's vehicle to have a broken taillight. "I didn't get a close look," Brooks said. "You didn't get a close look at the taillight of the vehicle before you arrested the occupant for stealing it, this supposedly stolen vehicle, and you didn't examine the details that would allow you to verify whether it matched the report." The prosecutor stood to object, but the judge overruled her. The objection was the last gesture of a defense that was already failing. Brooks had to answer. "I radioed in for verification," he said. David Chen retrieved the dispatch logs and showed them to the judge. They were then projected on the screen. The logs showed that Officer Brooks had not radioed for verification until 17 minutes after the arrest. The timestamp was clear. The sequence was undeniable. You arrested her before you verified whether she had actually stolen the car. You made the arrest first and checked her information second? Brooks's jaw tightened. He was beginning to understand that he was not going to be able to maintain his narrative, that the facts were arranged against him in ways that could not be explained away. "I had probable cause," he said. "Based on what? The color of the car or the color of the driver?" The prosecutor objected. The judge overruled again. This objection was also the last gesture of a defense that had already failed. "I think," the judge said, "it's a fair question." Brooks did not answer directly. Instead, he explained that he had relied on his training, on his instincts, on the totality of the circumstances. Judge Johnson's demeanor had seemed evasive. The neighborhood had been experiencing car thefts. He had followed his training. Chen then produced Dr. Hoffman's statistical analysis. The large screen showed the graph, the bar chart showing traffic stops by race. The bar for black drivers was nearly 4 times the height of the bar for white drivers. Brooks was asked to review the data showing that he stopped black drivers at 4 times the rate he stopped white drivers, that he found contraband at 1/4 the rate. "Officer Brooks, you've been complained about 14 times during your career," Chen said, his voice steady and clear. 14 times. Were you aware of that? "I was aware some complaints had been filed." "And they were all dismissed?" "I believe so." "Without investigation?" Silence filled the courtroom. Brooks did not answer. His refusal to answer became itself an answer. The jury is about to decide, but before we get to the verdict, I want to ask you, what do you think the jury should award? 1,000, 10,000, 100,000, 1 million? Comment your number right now. Tell me what you think justice looks like in this case. And after you comment, subscribe, because the next video might be even bigger than this one. You're not going to want to miss what comes next. The jury deliberated for 3 hours. When they returned, the foreman stood. The verdict was guilty on all counts. On false imprisonment, guilty. On civil rights violation, guilty. On unlawful arrest, guilty. 3 findings of liability. Then came the damages. Compensatory damages, $200,000. But the jury understood that compensation alone would not be sufficient. They understood that Officer Brooks had not learned from 14 prior complaints. They understood that the department had not acted. Therefore, the foreman announced punitive damages in the amount of $1 million. The total judgment was $1 million too, was $100,000. Officer Ethan Brooks, earning $47,000 a year, was now liable for a judgment exceeding 25 years of his salary. In the courtroom gallery, Mariah sat with her hands folded in her lap. Michael held her hand. When the verdict was announced, she did not cry, she did not smile. She simply exhaled, a slow release of tension that had been building for 18 months since that evening in her driveway. Justice had been served, not revenge, justice. 2 weeks later, Officer Brooks was fired. The Department of Justice opened an investigation. The police chief announced new bias training and revised procedures. 6 months later, Mariah established a legal defense fund for individuals who had been wrongfully arrested. This is what happens when someone fights back. This is what happens when a system is forced to look at itself. But this only happened because Mariah Johnson refused to stay silent, because she was willing to spend 18 months in a courtroom because she believed accountability mattered. And here's the truth. This movement grows because of you, because you watch, because you comment, because you share. I want to ask you 3 things in the comments. First, what's your take on this verdict? Do you think $1.2 million is enough? Second, have you ever experienced something similar? I read every single comment. Tell me your story. And third, if you believe in accountability and justice, subscribe, hit that notification bell, share this video with someone who needs to see it. Let's build a community that cares about accountability. Comment below. I'm reading.